You're watching Bloomberg Law. I'm Lee Pacchia. Law firm Dewey LeBoeuf has filed a Chapter 11 bankruptcy case in the Southern District of New York Bankruptcy Court. Here to parse through the filing and what lies ahead, we have Kent Zimmermann, consultant to law firms at the Zeughauser Group, and our own Bill Rochelle from Bloomberg News. Welcome to you both. Kent, it's a sad day, but we've been waiting for this case to hit for a while now. The largest law firm to go bankrupt was in a death spiral for weeks, if not months. At what point was this filing a foregone conclusion?
You know, Lee, when I first heard about this earlier this year, I thought this is a firm that's too big to fail. It's a mainstream New York firm, terrific reputation, had above average, well above average lawyers across the firm. But as I heard more and more about the finances of the firm, it wasn't long, early in the first quarter, before I realized this was never going to work out for the firm and they were going to go down. I knew that this would rock the industry. Mm-hmm. That's exactly what is happening now.
Mm. When you say the finances, you mean the debt levels?
You know, it was the debt level, but if you parse through the debt and you look in particular at the compensation arrangements the firm had with both incoming lateral partners as well as legacy partners, that's when I realized there was trouble. So there is said to be $100 million in deferred compensation, but what really got my attention was that 1/3, a full 100 of the firm's 300 partners had unconditional compensation arrangements. That's what's been reported. And if you think about it, when you have compensation arrangements with that many partners untied to performance and then the firm's revenue dips, that's a recipe for disaster.
Bill, speaking of the partners, how much are they ultimately going to be on the hook for in this bankruptcy case? Presumptively, at some point, they're going to have to reach into their pockets and give some money back to the estate. Any idea as to how much and when we're going to have a feel for what that's going to look like?
In a case like this, it takes years before you really find out what the ouch factor turns out to be for the partners. But they have a lot of problems to worry about. First off, of course, their capital is gone. Gone, up in the air, blew away. Second, they're going to face the likely prospect of being sued for fraudulent transfers. In other words, somebody's going to come up with a theory that partner profit in the last 6 months, a year, you name it, didn't exist. And so therefore, they really weren't entitled to be paid anything. And this all will take the form of fraudulent transfer suits with mighty large ad damnums on it against each of the partners. And in addition to that, there was a decision just last week from a federal district judge in New York in the liquidation of Coudert Brothers, saying that departing partners have got to pay, let's call it the profit, on work they take with them to their old firm.
Right, major decision, and it should play out in this case as well, correct?
Right.
Kent, I guess we're going to have to speak about what capital remains in the estate. When you're talking about law firms, it's difficult because essentially at the end of the day, it's the doorknobs, chairs, desks, and the accounts receivables. In the first day papers, it was said that Dewey has historically been able to collect 95% of its account receivable and convert 84% of its work in progress accounts to accounts receivable. Is that going to hold up through the bankruptcy proceedings, or is that number going to drop off? And if so, how much?
It's a great question, Lee. No way is that going to hold up is the short answer. The longer answer is, from what I read, the firm has about $255 million in accounts receivable. One of the first things that the administrator is going to do is try to collect that money. It's going to be tough sledding. That's going to be an uphill battle. If history is any guide, clients are far less likely to pay once a firm goes into bankruptcy. It's highly unlikely they'll be able to collect at their historic rates, likely much lower than that.
And I'd like to say there's one other factor that plays into this too, and this is new as of, let's call it this year. And that is when you're suing a, let's call it former client for an uncollected bill, the bankruptcy judge probably does not have the authority to conduct that trial. Or if he does, he can only issue a recommended finding. This is going to mean an extra layer of trouble in trying to collect accounts receivable from former clients. And if you're a former client who doesn't try to ride that horse, something's wrong with you.
Well, talking about how this case is ultimately going to go. Bill, on the podcast, we've always said that New York is a jurisdiction that's very good if you have a large case that's expected to get litigious. Now, Dewey LeBoeuf was a New York firm by all accounts, but at the same time, you have to wonder, does it help that they're in New York if they expect this case to get shouty? Is that where this is all going to head?
Well, New York is a good place in difficult cases, and this, very likely will be difficult in some aspects, but, it's really nowhere else to go. It was like a triple play. They are a New York law firm. They're a big enterprise which files in New York, and there's really no reason on earth they should be anywhere else.
Ken, we were talking before about how you saw this this filing, this dissolution of a grand law firm as part of a Darwinian shakeout that's happening in the legal profession. Are there going to be more big firms failing, and if so, which ones?
Great question. What I would say is more firms will fail. It'll most likely be the weaker firms that fail. I would say yesterday or Monday when they filed, it was a sad day in the legal industry. The people I feel for are the junior attorneys and some of the staff. They're going to have a hard time finding work. But if you look at the big picture, when firms fail, when weaker firms fail, and Dewey was one of the weak ones towards the end, that makes the industry stronger. Stronger firms get even stronger. In this case, there are some strong firms that picked up very high-quality talent from Dewey, and they're going to be even stronger as a result. So the industry will be stronger when there's fewer weak firms and more strong firms in it. Will other firms fail? Absolutely. Those that fail will have trouble adapting to their changing environment. They either won't want to or won't be able to adapt to change. And there's dramatic change in the industry right now.
Kent, question for you. What do you think the likelihood would have been that Dewey would have failed just on account of the $225 million of secured debt?
Unlikely is my answer to that. What hurt at Dewey was that there was a crisis of confidence in leadership. That crisis of confidence arose because there was not consensus in the firm about the firm's growth strategy. Just to give you a little more on that, there was a decision made by senior leadership at the firm to grow by taking in a large volume of laterals, and that's not a mistake in and of itself, but what they did was they quietly offered guaranteed compensation to those laterals untied to performance. They did that without apparently disclosing it to all of the partnership. When that became clear in a late December meeting at the firm, as has been reported, and partners were stunned that that was the management decision that had been made, that is when a crisis of confidence occurred and a trickle of departures ultimately turned into a stream. That unraveled the firm. If you look at other dissolutions, other troubled firms, a crisis in leadership preceded the collapse. This was a similar case along those lines, is what I would say.
Bill, what does your gut say about what's happening in law? Is Dewey a one-off, or do you think we're going to see more firms failing in coming months and years?
Well, the notion has been going on now for, 30 years at least, is that bigger is better. Problem is, in law, you can never get truly big enough to have a really commanding market share, at least not across the board. Maybe in some isolated areas you can. I'm not sure that bigger is better really works, especially when getting bigger is very expensive. One theme there is in all law firm failures is when you take on debt to get larger and then your revenue falls off, everything unwinds. And it's always seemed to me like significant debt is the death knell for a law firm, because once you stop growing, if you got a lot of debt, you start dying.
All right. Well, gentlemen, we're going to leave it there for now, but it looks like we're in for a long and difficult case, not only with the Dewey situation, but also with what's happening in the legal profession in general. I'm sure we'll be talking about these issues again. Thank you for coming in. That's Bloomberg News editor-at-large Bill Rochelle and Kent Zimmermann from the Zeughauser Group. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube and see our updates on Twitter. I'm Pacchia. Thanks for watching.